Welcome back, everyone, to the deep dive. You know, today we're diving into some pretty heavy stuff, and honestly, I'm a little concerned about what these reports reveal. It's about freedom of expression, or maybe lack of it, in Southern Africa.
Yeah, no, it's definitely worrisome. I mean, just glancing at these sources, the thing that really hits you is how different countries are tackling this. Well, I guess you could say tackling. It's more like they're trying to control what people can say, especially if it goes against the grain.
Right, exactly. So for this deep dive, we're zeroing in on two countries in particular, Eswatini and Zimbabwe. And in both, what we're seeing are very specific instances where people just trying to speak their minds, whether they're politicians or journalists, are facing some serious pushback. It's like their basic right to express themselves is under threat.
Yeah, and a good place to start is with Eswatini. There's this case, really highlights the situation, involving two former members of parliament, Mduduzi Besed Mambuza and Mfandeni Dube. These guys got hit with some pretty hefty prison sentences, 25 years for Mambuza and 18 for Dube. The charges, well, they range from sedition and terrorism to even murder.
And from the get-go, it's clear that their political speeches are right at the heart of these convictions. The Southern Africa Litigation Center, SADC, they point out that the main issue seems to be that these guys were advocating for democratic reforms. Specifically, they were pushing for the people to be able to directly elect the prime minister, having a say in who leads them.
Absolutely, and that's a big deal because right now, Eswatini is Africa's last absolute monarchy. So these MPs calling for a shift away from that, demanding the prime minister be chosen by the people, not the monarch, well, let's just say it put them on the government's radar in a big way.
Okay, so then we look at Zimbabwe, and it's like a whole different scene, but still super worrying for freedom of expression. The case of Blessed Mlanga is a prime example. This journalist is facing legal challenges, and it all goes back to some interviews he did with a war veteran who dared to criticize the president.
And the thing is, this Mlanga case, it's not just a one-off in Zimbabwe. We've seen this troubling trend of journalists getting into legal hot water in recent years. Like, remember Jeffrey Moyo? He got convicted for immigration issues related to his press credentials. Even though he didn't end up in jail right away, it was a huge red flag. And then there were the arrests of Hopewell Chinono and Mduduzi Mathuthu, both journalists making waves and facing consequences. It paints a pretty bleak picture.
So for this deep dive, we're really going to dig deep into how freedom of expression is being challenged in both Eswatini and Zimbabwe based on these reports you brought. We want to understand exactly how it's happening and what it means for the bigger picture.
Exactly. Get into the nuts and bolts of it all.
Okay, let's start unpacking this, and let's begin with Eswatini. What exactly happened that led to this crackdown that Mambuza and Dube got caught up in?
Well, the SADC report goes into detail about how things unfolded. Back in May 2021, protests broke out in Eswatini. It all started after an alleged incident of police brutality, but it quickly snowballed into this massive call for democratic reforms. The people were demanding change.
And the government's reaction, it wasn't exactly subtle, was it?
No, not at all. They came down hard. The government immediately slapped a ban on all protests and demonstrations, and they even authorized their security forces to use, well, lethal force against the protesters. It was a brutal response. By July of that year, reports were indicating that something like close to 100 protesters had been killed. It was a really dark period.
It's against that backdrop that we need to understand what Mambuza and Dube did and the charges they ended up facing. Their speeches, the ones that landed them in so much trouble. What was the core message they were trying to get across?
Okay, so in the month leading up to this crackdown, Mambuza and Dube delivered 6 speeches. And the main thrust of their message was this urgent need for democratic reforms, with their top demand being the direct election of the prime minister. They were basically rallying their constituents to put pressure on the government to petition them for this change.
And it sounds like the government saw that as a direct challenge to their authority.
You got it.
Yeah.
On June 24, 2021, the government issued this, what they called a banning order. It specifically prohibited anyone from delivering any more petitions. And get this, that very same day, Mambuza, he basically tells his constituents to ignore the order and keep those petitions coming. He straight up called the order unconstitutional and unlawful and basically encouraged people to defy it. Talk about standing your ground.
And here's where it gets really interesting. The sedition charges against them, it seems like they hinge almost entirely on what they said in those 6 speeches.
You're absolutely right. That's a key takeaway here. The SALC analysis of the court ruling, it points out that the vast majority of the ruling, I'm talking over 100 pages out of 148, was dedicated to just dissecting these speeches word for word. It was like an obsessive deep dive into their every utterance. Only a small fraction of the ruling actually even dealt with the murder charges.
So let's get specific here. What laws did the prosecution argue that these speeches actually violated?
They focused on two main pieces of legislation. The first was the Suppression of Terrorism Act of 2008, and it's important to note that this act has been amended since it was first introduced. And the second was the Sedition and Subversive Activities Act of 1938. Now, both of these laws, they've been criticized quite a bit for potentially infringing on people's constitutionally protected rights, like freedom of expression, assembly, and even belief, especially the Sedition Act. It's an old piece of legislation that has a long history of being used to target anyone who dares to speak out against the government or the monarchy.
And this is where it gets truly alarming. The report highlights that the prosecution actually used parts of the Sedition Act that had been declared unconstitutional way back in 2016. I mean, how is that even possible?
Yeah, that's the truly mind-boggling part. Even though the Supreme Court had agreed to hear an appeal against that 2016 High Court ruling, SALC makes a really good point that, legally speaking, that High Court ruling should stand as the law of the land until the Supreme Court comes out and says otherwise. But there's even more to it. Back in 2019, a case called Goodwill Sibia be the King, the Eswatini court itself had clearly stated that using legislation that's already been deemed unconstitutional to prosecute someone, well, it throws a wrench in the whole system. It undermines previous court judgments, and it also infringes on the accused person's right to a fair trial. I mean, it's a pretty clear indication that the legal system is being manipulated to achieve a specific outcome.
It feels almost calculated, like a deliberate attempt to shut down anyone who steps out of line. SALC even suggests that this insistence on using the Sedition Act, despite it being partially struck down, might be less about upholding the law and more about sending a clear message. Like, hey, we're watching, and we'll use whatever means necessary to punish dissent, even if it means bending the rules.
I think that's a very valid interpretation, and the severity of the sentences, that definitely adds fuel to that fire. The entire prison sentences for Mabuza and Dube, they stem from the convictions under the Terrorism Act. And remember, those convictions were based solely on their speeches. Meanwhile, the sentences they received for the murder convictions, those were actually shorter. It's like they're saying, speaking your mind is a bigger threat than actual violence.
Yeah, that's a really chilling point. It suggests that in the eyes of the court, expressing dissenting political views is considered a far more serious offense than even taking a life. Kind of boiled down to that statement from SALC. Dissent will not be tolerated. End of story.
Yeah, it's a pretty stark warning.
Okay, so let's move on to the murder charges themselves, because that adds a whole other layer of complexity to this case and raises even more questions about freedom of expression. As we've said, Mabuza and Dube were charged with the deaths of two protesters who were killed when a car hit them at a roadblock.
A really tragic situation, and made even more complicated by how it was tied to the MPs.
Right, because the court itself acknowledged that neither Mabuza nor Dube were anywhere near that roadblock when the incident happened. And there's no evidence that they ever endorsed violence in their speeches. In fact, they explicitly called for peaceful action. So how could they possibly be convicted of murder?
That's where this legal doctrine called dolus eventualis comes into play. It's a bit of a legal head-scratcher.
Okay, so let's break down dolus eventualis. In layman's terms, what is it, and how is it usually applied in legal cases?
Basically, dolus eventualis is this legal concept that allows someone to be held liable for murder even if they didn't directly intend to kill. It hinges on the idea that they acted recklessly in a way that was unlawful, and they knew, or should have known, that their actions could lead to someone's death, even if that wasn't their primary goal.
So it's about foreseeing potential consequences, even if you're not directly aiming for them.
Right. Think of it like, I don't know, someone chucking rocks into a crowded street. They might not be aiming at any one person, but they know there's a good chance someone could get hurt. That's the essence of acting recklessly with potentially fatal consequences. The thing is, SALC explains that traditionally, Eswatini courts have applied this doctrine in cases where there's a pretty clear link between what the accused person did and the death of the victim, even if you can't prove they were out to kill them. They give the example of a 2023 case, Rex v. Nchidisi Johnson. In that case, the defendant stabbed the victim multiple times.
So applying this doctrine to Mabuza and Dube, who weren't even present when the protesters were killed, seems like a pretty big stretch.
It's a huge stretch. In fact, it was widely seen as completely unprecedented. And it drew a ton of criticism. Critics were basically saying, come on, are we really supposed to believe that these MPs could have known that urging people to deliver petitions peacefully would somehow lead to people getting killed by a car at a roadblock miles away? It just doesn't add up. Some legal experts even accuse the court of completely misunderstanding how dolus eventualis is supposed to work. The really concerning takeaway here isn't just the convoluted legal maneuvering, it's the chilling message it sends. That any connection, however tenuous, between someone's speech and some unintended harm could land them in serious legal trouble. It's like making activists responsible for the unpredictable actions of others.
That's scary. It almost criminalizes free speech itself. I mean, SALC points out that this sets a dangerous precedent. Could this mean that any political activist could be held criminally liable for any harmful outcome that's even loosely connected to what they've said, no matter how far-fetched the link?
That's the terrifying reality of it. It basically throws a blanket of fear over any kind of political activism. SALC concludes that it's really hard to look at this case and not see it as a clear-cut example of Mabuza and Dube being punished not for any actual crime they committed, but for daring to challenge the government. Their words were their crime.
And those disproportionate sentences, they really hammer that point home. They get longer sentences for terrorism based entirely on their speeches than for the actual murder convictions. It's a pretty blatant attempt to silence dissent. All right, let's shift gears now and take a look at Zimbabwe. It seems like the situation with journalists there is a different kind of battlefield, but the underlying threat to freedom of expression is very much the same. So let's start with the case of Jeffrey Moyo. What exactly happened there?
So Jeffrey Moyo was working for the New York Times, and back in May 2021, he was arrested and ended up spending 21 days behind bars. The charge against him was that he had obtained fake press credentials for 2 New York Times journalists who were coming into Zimbabwe to do some reporting.
And how did that case eventually play out?
Well, in the end, he was convicted of violating immigration laws. He got a 2-year suspended prison sentence and had to pay a fine. So while he didn't end up serving time right away, he publicly called the decision outrageous and irrational, and that suspended sentence is still hanging over his head. If he gets convicted of a similar offense within the next 5 years, he could end up in jail.
It's important to remember that Zimbabwe has a bit of a reputation for having restrictive media laws. The report even mentions the Access to Information and Protection of Privacy Act.
Oh yeah, that act, it was enacted under Robert Mugabe, and it's been notorious for clamping down on press freedom. It's led to the arrest of countless journalists over the years. That act basically gave the government sweeping powers to control the media and restrict what journalists could do. And even though Mugabe's gone, those restrictive tendencies seem to have stuck around.
And the reports you brought, they highlight a bunch of other recent cases where journalists have gotten into legal trouble. Can you give us a quick rundown of some of those?
Sure. There's Hopewell Chinono. He's an investigative journalist and a very vocal critic of the government. He was detained multiple times in 2020 after he expressed support for anti-government protests. Then there was that police raid on the home of Mduduzi Mthuthu. He's the publisher and editor of ZimLive.com. They later charged him with insulting the president in a tweet. Can you believe that? He could actually face a year in jail or a hefty fine for that. And remember, earlier this year, Blessed Malanga, the journalist we talked about earlier, he and another journalist, Chinjet Ochadi, were arrested for simply taking pictures of police officers detaining an opposition lawmaker. They're facing potential jail time and fines under the criminal code. So it's pretty clear that Zimbabwe is using the legal system to intimidate and silence journalists who are just trying to do their jobs. It echoes what we're seeing in Eswatini, even though the specific tactics are different.
It's a worrying trend for sure, especially considering that after Mugabe was ousted, there was this initial hope that things might improve for journalists in Zimbabwe. But their ranking in the World Press Freedom Index has actually been going down, which is not a good sign.
No, not good at all. Reporters Without Borders, in their latest report, they pointed out that while Zimbabwe did see an initial improvement in its ranking after the coup, that progress has stalled, and the past few years have seen things backsliding. They highlight that some really harsh laws are still on the books, and even the new laws that have been introduced often contain provisions that are just as restrictive as the ones they replaced. They specifically mention the amended Penal Code, the Official Secrets Act, and this new Cybersecurity and Data Protection Act as all being problematic for journalists. And they also raise some serious concerns about the practical protection of source confidentiality in Zimbabwe. It's like 1 step forward, 2 steps back.
Which brings us back to the most recent arrest of Blessed Malanga in February 2025. Can you walk us through the specifics of that case? So this latest arrest, it directly stemmed from those interviews Malanga conducted with a war veteran named Blessed Geza. In these interviews, Geza was pretty critical of President Mnangagwa, especially when it came to the economy and how the country was being run.
So what charges is Malanga facing this time around?
He's been hit with transmitting of data messages inciting violence or damage to property, charges he's strongly denying. His bail hearing was adjourned, and his lawyer is raising some big red flags. He's concerned about how this arrest is going to scare other journalists into silence and whether it's even constitutional. He points out that Zimbabwe's own constitution guarantees freedom of expression and of the press, so there are some serious legal questions at play here.
It's interesting, though, to hear the perspective of the ZANU-PF information director. He claims that Malanga will get a fair trial and that this whole arrest shouldn't be seen as a reflection of the state of press freedom in Zimbabwe. His comment about no journalists being killed was a bit of a, I don't know, a dismissive way to brush off the concerns, wasn't it?
Yeah, it came across as pretty tone-deaf. But media watchdogs, like Reporters Without Borders, they're painting a very different picture based on what they're seeing on the ground. They've observed that while things did initially improve after Mugabe left, there's been this noticeable uptick in the persecution of journalists since the 2023 election. Journalists are being obstructed, harassed, briefly detained, even assaulted in some cases. And as we mentioned earlier, Malanga himself was actually arrested before, back in 2022, so this isn't just a one-off incident.
It's clear that Malanga's arrest has sparked a lot of condemnation from both international and local media rights organizations.
Absolutely. The consensus seems to be that this is another bad sign for press freedom in Zimbabwe, a step in the wrong direction.
So zooming out a bit, it feels like what we're seeing in Eswatini and Zimbabwe, these aren't just isolated incidents. SALC actually connects these events to this broader regional concern about freedom of expression. It's like a worrying trend spreading across southern Africa.
Yes, definitely. In their statement about Malanga's arrest, SALC called it part of a troubling trend of state-sanctioned aggression against the press. And they highlighted what they see as this systematic erosion of freedom of expression across southern Africa. It's like a slow, creeping crackdown on free speech.
And they really emphasize how crucial a free press is for any democracy to function properly.
Exactly. SALC reminds us that a free press is absolutely vital for holding those in power accountable, for making sure citizens are informed, and for creating a space for open and honest public dialogue. They argue that when governments start criminalizing the work of journalists, it undermines the very foundations of democracy and the rule of law. It erodes those core principles that are essential for a free society.
And they're not just sitting back and watching this happen. They're actually calling for action from regional and continental bodies.
That's right. They've directly called on SADC, the Southern African Development Community, and the African Commission on Human and People's Rights to step up and condemn these attacks on journalists and press freedom. They're urging these organizations to hold member states accountable, demanding that they actively protect journalists and get rid of these oppressive laws that are being used to stifle free speech. It's a call to action saying enough is enough.
And it's not just about these two countries either. That report on ambiguous laws, it highlights similar issues in other African countries like Kenya and Botswana, where vague legislation is being used to stifle freedom of expression. It's like a playbook being shared across borders.
Exactly. A good example is the Kenyan Supreme Court's decision to strike down Section 77 of their penal code. That section was originally intended to prevent subversion, but the court found that it was worded too broadly and was ripe for abuse. It's a prime example of how these ambiguous laws can be twisted and used to silence dissent. And SALC is actually challenging a similar provision in Botswana's penal code that criminalizes publishing alarming information. It's like they're trying to make it illegal to report on anything that might upset the status quo.
So when we look at all of this together, these specific incidents in Eswatini and Zimbabwe, coupled with these broader regional concerns about the misuse of ambiguous laws and these delays in the courts, it paints a pretty grim picture for democracy and fundamental rights across southern Africa.
It does. These aren't just isolated blips on the radar. They're interconnected threads in a larger pattern that raises some serious questions about the health of democratic institutions in the region.
So as we wrap up this deep dive into the state of freedom of expression in southern Africa, based on these really insightful but concerning reports you've shared, what stands out most to you from these accounts? What are your takeaways? I mean, we've seen everything from sedition and terrorism charges based solely on political speech in Eswatini to the outright criminalization of journalism in Zimbabwe. It's pretty stark contrast in approaches, but with the same chilling effect.
For me, it raises this big question about the role of the judiciary in all of this. Are the courts truly acting as guardians of fundamental rights like freedom of expression? Or are they, maybe unintentionally or maybe not, actually contributing to the erosion of these rights through how they apply the law or through these unexplained delays in delivering crucial judgments? It's a question that needs some serious thought.
It really makes you appreciate the importance of a free press and the ability to voice dissenting opinions, even when those opinions might ruffle some feathers. These things are essential for any society that wants to call itself free and democratic.
Absolutely. Without these fundamental freedoms, citizens can't hold their governments accountable. They can't truly participate in shaping their own society.
So here's a final thought for our listeners to chew on. If simply speaking your mind or reporting on what's happening can land you in deep trouble, what does that tell us about the state of democracy in Southern Africa? Are those democratic principles strong enough to withstand the pressure when those in power feel threatened? It's a question we all need to grapple with. And, as always, we encourage you to keep digging into these issues, explore them further, because understanding what's happening in Southern Africa and what it means for the future of democracy in the region is crucial. It's something that affects us all.